This morning, the Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers.
The Supreme Court's emergency docket, also called the shadow docket or the interim docket, is for, well, emergencies. This is every time the federal government had a case there, back to the first Trump administration. And here's just 8 months into his second term. It's being used in record numbers.
Emergency applications used to be a very, very small and not especially divisive part of the Supreme Court's work. Now, this is the front lines.
Not only are there more of these cases, but President Trump is winning more than his predecessors have. And we don't really know why.
We don't know why, because with this shadowy process, the Supreme Court doesn't have to tell us.
8 months into the second term, and the government has filed more emergency applications to the Supreme Court than at any comparable point in modern history. That number, not more than any predecessor, more than any comparable period, is the thing I keep coming back to because it tells you something specific about how the executive and the judiciary are actually operating right now. Not through the normal appellate process where cases take years and produce written opinions explaining the court's reasoning. Through the shadow docket, emergency applications, orders issued without full briefing, without oral argument, often without any written explanation at all. The shadow docket was designed for genuine emergencies. It has become the front lines. And here is what that means practically. When the Supreme Court issues an order through the shadow docket without a full written opinion, the scope of that order is immediately contested. The administration argues compliance means X, the petitioners argue it means Y. There is no detailed reasoning to anchor the interpretation. Both sides go back to the shadow docket to resolve the dispute. That cycle
Dislikes these judges.
The Ninth Circuit is a disaster. Nobody can believe these decisions we're getting from the Ninth Circuit. It's a disgrace. The Ninth Circuit, everybody knows it. It's totally out of control.
When Trump took office, most of the Ninth Circuit's judges had been appointed by Democratic presidents, and they overruled some of Trump's most provocative executive orders. The travel ban, emergency funding for a border wall, they all stopped here.
Very hard to win at the Ninth Circuit, if not impossible.
A big win for President Trump today as the Supreme Court denies Democrats access to grand jury material from Robert Mueller's Russia investigation, at least for now anyway. The court agreed to hear the administration's appeal of a lower court ruling that the documents be turned over to the House, which likely would not happen until after the 2020 election. House Judiciary Committee Chairman Jerry Nadler putting out this statement saying that he is confident Democrats will
order, contested compliance, emergency application, another order, is the operating environment the court defiance story is happening inside. Subscribe right now and hit the notification bell, leave a like before we go any further, because what I'm about to walk through about why the HRES 353 predicate is analytically cleaner than the first two impeachments, and what the shadow docket has to do with it is the framework most coverage is completely missing. I've been sitting with this for a while and I want to make sure you have it. The specific Supreme Court ruling the document describes a way ordering Trump to reinstate immigration protections, stop deporting people without hearings, make efforts to return those wrongly deported. I need to be careful here about verification. The specific ruling as described is presented as established fact in this document. I cannot independently confirm all of its specific details. What I can confirm, courts at multiple levels have found Trump's immigration enforcement violated statutory procedural requirements. The pattern of deportations occurring before required hearings is documented. The irreversibility problem, people deported to dangerous countries who cannot be located or brought back, is documented. The constitutional analysis holds regardless of the specific ruling's exact terms. And that analysis is what matters. When a court orders the executive to do something specific, not just follow the law generally, but reinstate these policies, stop these specific actions, make efforts to return these specific people, and the president publicly refuses, there is no interpretive dispute about what happened. The order exists, the refusal exists. Both are documented. That is analytically cleaner than Ukraine. Ukraine involved disputed facts about what was said on a phone call and what the intent behind it was. Reasonable people could disagree about whether the conduct rose to the level of high crimes and misdemeanors. That is analytically cleaner than January 6th. January the 6th involved disputed interpretations of a speech, whether it constituted incitement, whether Trump was legally responsible for what followed. A Supreme Court order and a public refusal to comply do not require interpretive work. The order is there. The refusal is there. The Article 2 obligation to faithfully execute the laws is there. The gap between the obligation and the conduct is measurable and documented. That is what makes HRES 353 the accountability predicate that is hardest to defend against. I should correct something the document gets wrong. It says Democrats control the House and would only need a simple majority to impeach. Republicans control the House with a 5-seat majority. This series has documented that throughout. That changes the impeachment calculus significantly. Articles in a Republican-controlled House require Republican members to either vote yes or be recorded as voting no on impeaching a president for defying the Supreme Court. Those are both uncomfortable positions in competitive districts. The document's error matters because it changes the political story. This is not Democrats impeach and Republicans block in Senate. This is, can any Republicans in the House be moved? And what does the vote record look like going into November 2026 for members who voted to protect a president who defied SCOTUS? The immigration enforcement piece, the people who were deported before receiving required hearings, the asylum seekers whose cases were pending, the individuals removed in violation of their documented legal rights, is where the human stakes of the court defiance scenario become concrete in a specific way. Once someone is deported to a country they were fleeing, the harm cannot be undone by a subsequent court order. You cannot undeport someone who has been imprisoned, who has gone into hiding, who cannot be located. The court ordering efforts to return them is a recognition that the harm has already occurred and may be irreversible. That irreversibility is the specific legal problem that distinguishes this category of enforcement violation from most. A president who overspends his appropriations can be corrected prospectively. A president who deports people before their hearings may have caused harm that no judicial order can repair. When courts ordered the executive to make efforts to return wrongly deported individuals rather than simply commanding their return, that language was a recognition of this irreversibility problem. You can only order efforts because return itself may not be possible. That is why the enforcement question has its own specific legal and moral weight separate from the constitutional crisis question. Both are real. They are different dimensions of the same problem. The shadow docket context comes back in here because the irreversibility problem is exactly why the emergency docket has become so active in immigration cases. Both sides understand that a regular appellate timeline, months, years, produces outcomes where the emergency is over before the court rules. People have been deported, the harm has occurred. A ruling against the practice 3 years later does not help the people who were removed before the ruling. The emergency of the shadow docket reflects the irreversibility problem on both sides. The government argues that judicial stays of enforcement create their own harms. Petitioners argue that allowing enforcement to continue while cases are litigated produces irreversible harms that cannot be remedied after the fact. The court is being asked, through emergency applications, to make real-time decisions about irreversible consequences, without full briefing, without oral argument, often without written explanation. That is the operating environment. And Trump being described as winning more shadow docket applications than predecessors. The clip identifies this, and it is documented, tells you something about how the current court majority is assessing those emergency requests in real time. The impeachment dimension sits at the end of this chain. Court finds violation, executive refuses compliance. Congress faces the constitutional question of whether to tolerate that refusal or use its impeachment power. Courts cannot physically compel the president. That is the constitutional design. Not a bug, not an oversight, the actual design. The founders gave Congress the tool for exactly this scenario. Whether Congress uses it depends on 218 votes in the House and 67 in the Senate, and both of those numbers are constrained by the political environment, the 5-seat majority, and the November 2026 midterms define. What the HRES 353 predicate does, regardless of whether it produces an impeachment vote now, is establish in the permanent congressional record a documented constitutional argument that specific conduct, defying a Supreme Court order, meets the Article 2, Section 4 standard for high crimes and misdemeanors. That argument is on the record. Whether the votes are there to execute on it is a separate question. The shadow docket keeps running. The emergency applications keep coming. The irreversibility clock keeps ticking for the people caught inside the enforcement disputes. One more thing about the shadow docket that I think deserves direct treatment because the clip gets at it and most coverage walks past it. The clip says the court is winning more often for Trump than his predecessors did, and then says, we don't really know why. We don't know why, because with this shadowy process, the Supreme Court doesn't have to tell us. That observation is analytically important. When the court issues a shadow docket order granting a stay or denying one, it is making a real-time judgment about the likelihood of success on the merits, about irreparable harm, about the balance of equities. But because the order comes without written reasoning, the only public information is the outcome. 6 justices said yes or no. That is all you know. That opacity creates a specific problem for the compliance dispute. If the court grants a stay of a lower court injunction without explanation, the administration argues this signals the court agrees the injunction was wrong. If the court later issues a merits ruling against the administration argues the stay was about procedural posture, not substantive agreement. Both arguments draw from the same opaque record. Courts have always had to manage this tension between speed and transparency on emergency applications. What is different now is the volume and the stakes. When emergency applications were rare and involved genuinely narrow, time-sensitive situations, the opacity was manageable. When the shadow docket has become the primary arena for the most consequential constitutional disputes of the term, the opacity means the public is watching an entire constitutional confrontation play out without most of the reasoning being visible. That is why the compliance question is harder to resolve than it should be. Not just because the president refuses to comply, because the court's own orders come without the full reasoning that would make compliance requirements unambiguous. The gap between the order and the reasoning is where the administration's compliance claims live. Fill the gap with your preferred interpretation, and you can claim compliance while doing nothing you were ordered to do. The Jackson parallel from the first DH commentary on this topic is still the most honest historical frame. Jackson refused to enforce Worcester v. Georgia. The Trail of Tears followed. Jackson is condemned by history for that refusal. But there is a specific difference between Jackson's defiance and the current situation that is worth naming. Jackson's defiance was of a ruling about a third party, the Cherokee. The current defiance, if the document's description of the ruling is accurate, is of orders about people who were supposed to receive process from the government that was ordered to provide it. The government is both the party ordered to act and the party refusing. That self-referential loop, the government ordered to provide process, the government refusing to provide process, the court unable to physically compel the government to provide process, is what makes the enforcement problem structurally intractable without congressional action. HRES 353 is in the record. The shadow docket keeps running. November keeps getting closer. I'm David Harper. Something I keep returning to, the specific language of the deportation order problem and why make efforts to return is doing more legal work than it appears to. When courts order the government to make efforts to return wrongly deported individuals rather than ordering their return directly, that language is the court acknowledging a specific limit of its own authority. The court can order the government to try. It cannot order the foreign country to accept them back. It cannot order people who have gone into hiding to come out. It cannot undo deaths or imprisonments that occurred after deportation. Make efforts is the court's way of ordering what it can actually enforce while acknowledging what it cannot reach. That precise legal language matters because Trump's compliance arguments will almost certainly operate inside it. The administration can claim it is making efforts, some minimal action, some nominal attempt, while the practical effect of the wrongful deportations remains uncorrected. The court's order, precisely because it acknowledges its own limits by using make efforts rather than ensure return, gives the administration definitional space. That definitional space is where compliance disputes live, and resolving compliance disputes in shadow docket conditions, no full briefing, no oral argument, opaque reasoning, is exactly the environment where the administration has the most room to maneuver. I'm not saying this to diminish the significance of the court's order. The order is real. The predicate for congressional action is real. The irreversibility problem is real. The faithfully execute obligation is real. I'm saying it because understanding where the administration's maneuvering room exists is the only way to assess what congressional action would actually need to accomplish. Not just impeachment as a response to a single dramatic defiance. Impeachment as a response to a documented pattern of operating in the definitional space that opaque judicial orders create. Taking the minimum possible action, claiming compliance, and waiting for the next shadow docket round. That pattern, if it is what is actually happening, is harder to impeach successfully than a single clear refusal. It is also arguably more corrosive to the rule of law over time, because it does not produce a single undeniable defiance moment. It produces accumulated erosion in which each individual compliance claim is disputable, and the aggregate effect is that court orders have no practical consequence. Whether that is what is happening requires more information than this document provides and more verification than I can offer here. What I can say is that the analytical framework for understanding the constitutional crisis is not just did he comply, yes or no. It is, what does compliance mean in shadow docket conditions and who gets to define it? That question is live. The shadow docket keeps running. November keeps getting closer. I'm David Harper. The faithfully execute the laws clause, Article 2, Section 3, is the specific constitutional text that the court defiance scenario implicates most directly. I mentioned it earlier and I want to come back to it because it is worth being precise about what it actually requires. The president shall take care that the laws be faithfully executed, not may execute, shall, mandatory. The specific verb chosen by the founders was not discretionary. What does faithful execution require when a court has ruled on what a law demands? The legal argument the administration is making way that immigration enforcement is an inherently executive function, that the president has broad prosecutorial discretion, that courts cannot direct how that discretion is exercised, has a legitimate basis in constitutional law. Presidents do have real discretion in enforcement priorities. The question is whether that discretion extends to ignoring statutory procedural requirements that Congress already established. The statutory analysis runs, Congress passed immigration laws establishing specific procedures, hearings before deportation, asylum claim processes, protections for certain categories of individuals. Those procedures are federal law. A court finding that the executive violated those procedures is finding that the executive failed to faithfully execute laws Congress already enacted. The executive's discretion to set enforcement priorities does not include discretion to ignore the procedural requirements that attach to each enforcement action Congress required. That is the gap between legitimate prosecutorial discretion and the conduct at issue. Discretion over which cases to pursue is one thing. Skipping the legally required process for the cases you do pursue is another. The faithful execution clause bites hardest in the second category. The president has wide latitude over the first. The second is where the courts have consistently found violations and where the court defiance argument has its strongest constitutional foundation. HRES 353 is built on this foundation. Whether the political conditions exist to execute on it is the question November 2026 answers. The clip says Trump is winning more shadow docket applications than predecessors, and we do not know why because the court does not have to explain. I want to sit with that for a moment because it is the most analytically honest observation in the entire video, and it tends to get lost in the drama about constitutional crisis and court defiance. We do not know why. The court has a 6-3 conservative majority. 3 of those justices were appointed by Trump. The administration files emergency applications at record rates and wins more of them than predecessors did. But because the shadow docket does not require written reasoning, the public cannot assess whether those wins reflect the merits of the specific applications, the general ideological composition of the court, the specific legal arguments the Solicitor General is making, or some other factor. That epistemic gap, though we know the outcome but not the reasoning, is itself a constitutional problem separate from the specific dispute about immigration enforcement compliance. Courts derive legitimacy from public understanding of their reasoning. If the public can see the reasoning, it can assess whether the court is applying law consistently or applying it selectively. If the reasoning is opaque, the public is left with only outcomes. And outcomes without reasoning look from the outside like the court is simply counting votes. The shadow docket's expansion has been criticized across the political spectrum by constitutional scholars who are not at all aligned with each other on most things. The criticism is structural. A court that decides major constitutional questions through opaque emergency orders rather than reasoned opinions is a court whose authority rests increasingly on the power of its conclusions rather than the persuasiveness of its reasoning. That is a long-term institutional problem that outlasts any specific administration or any specific court defiance dispute. The cases being decided through the shadow docket right now, immigration, executive authority, the scope of judicial power, are the cases that will define constitutional law for the next generation. They are being decided without full reasoning on the record. Whatever you think about Trump, whatever you think about the specific immigration rulings at issue, that structural problem should concern anyone who thinks courts derive their authority from their reasoning rather than their conclusions. The shadow docket keeps running. November keeps getting closer. I'm David Harper.